giving this to me.
Thank you. Good morning and welcome to your North Carolina Court of Appeals. I'll be presiding today. My name is Judge Chris Dillon. To my right is Judge Richard Dietz, and to my left is Judge Lucy Inman. We have one case on the calendar, and after this case is over, we will briefly adjourn and we'll come back in for a ceremonial session once we're through with the oral argument. But we do have one case on the calendar today. It's Smith versus Novant Health, and we are ready to hear from the appellant. And if you'd like to reserve some time, just let me know how much you want to reserve, and I'll give you some verbal warnings. I know these lights may come up, but I'll kind of give you some warnings, so don't let that stress you out.
May it please the court, I'm Jay Trahey, and I represent the appellant Celeste Smith. While we are grateful for the opportunity to finally speak to this court about this case, I must confess we are even more grateful for the delay. Because, of course, as your honors know, in the delay came down the estate of Savino versus Charlotte Mecklenburg. And it pretty much answered many of the issues that would be otherwise be presented and made much more difficult for me in this case. I think my argument can be fairly short. I believe that in light of both the appellate decision in that case, Savino, and the Supreme Court case, I can rely upon my brief. There are a couple things I'd like to bring up. This case should have been, why was a medical device so improperly used? And the case looked at the hospital, the healthcare providers, and the system in which that occurred. The best part of our case, of course, was against the corporate hospital, as any plaintiff's lawyer will tell you, versus the very good people that work in healthcare. No one likes to sue them. I'll tell you that right now. But we had a case and we had an expert, and our best expert had to do with hospital administration and management. And because all of his opinions related to clinical care, our trial court was under the misunderstanding that prior to the 2000 law, and that law took place in October, this case was in March, the incident was in March, that prior to the 2000 law, all you could bring was ordinary negligence. And of course, that's not what we brought. We had an expert to do a number of things. One, that expert was going to say what the hospital policies were in light of federal regulations, hospital regulations, and everything else. He never got to testify about that because why? That dealt with clinical care. He was then going to testify about the management and their failure to train, and their failure to supervise, and their failure to enforce. Those are the very kinds of claims that the Court of Appeals approved of in the appellate decision in Savino. They listed in the 2014 complaint that had been brought the kind of allegations that should be brought, and if you look at our allegations, they mirror them. So the second purpose for the expert was to talk about what the management responsibilities were. The third part was to say, what is the standard of practice for hospitals? Now, this is independent from the standard of practice for the healthcare providers within them. It is the standard of practice for hospitals. We are going back down to retry this case, as you know. Your honors, looking at Savino, need to give us direction on what my expert, a hospital administrator who the judge lauded for his credentials and qualifications, to be giving opinions on hospital administration and management.
So let me ask you a few questions about that. So a very talented appellate lawyer once told me that sometimes in appeals, it's like a sporting event and the two teams show up on the field, and the problem is one team is wearing, a football helmet and pads, and the other has a baseball bat and, and mitts, and then really what the decision of who is going to win this appeal will come down to what game are we playing. And your friend for the defendant, I think, is going to say a lot of what's in your brief isn't really what's going on in this case. We're reviewing, at least on this issue, put aside the expert issue, but on the directed verdict issue, our review is de novo. And so, if the trial court said, well, I'm going to enter a directed verdict because I think the moon is made of blue cheese, we would still need to look and say, was it legally permissible? And your friend for the defendant's going to say, all of the claims ultimately come down to medical treatment, which is clinical, and which we have always held requires an expert who understands that clinical care. So explain to me why you prevail and that argument is wrong.
Make sure I have it right, because you ought to hit me with that. If you could just give me the question one more time.
So I think we're going to hear an argument that what the trial court was really doing, or what we, in our de novo review, what we should see the trial court is doing was saying, these are claims that need someone who is an expert in medical treatment to testify. There isn't that type of expert testifying here. Therefore, there's just not any evidence to allow these claims to proceed, and I will enter directed verdict, and that we should review whether that decision was correct. So my question to you is, if we're going to hear that, what's your answer to why the court erred here by entering the directed verdict?
Because the court directed a verdict very clearly on ordinary negligence. If you look at the entire record, what the court did with my administrative negligence claim is 12b6'd it. He dismissed it. And in fact, that's a very good point. Should I be required to prove to this court that I had enough in the record to beat directed verdict on an administrative negligence case? I believe that's your Honor's question, and it's the right one.
Well, there is no 12b6 ruling. There's no summary judgment ruling. We only have this directed verdict, right? So we're just, on de novo review, we're just saying, let's look at the record of the trial. Is there evidence that would support the trial court entering the directed verdict? And so, that's where I'm looking.
But my response to that, Your Honor, is on when we got to that point in the case, when we were looking at what to do with Mr. Moore, we could have put on a mini trial of 2 or 3 days and put on an offer of proof of what our administrative claim was. And that would have satisfied Your Honor's problem and my problem here. But that's not what happened. The court said, and if you look on page 3485 through 3487, I'm just not going to let you put on anything that has to do with clinical care, and go ahead so that the appellate courts can have a robust record in deciding whether or not my analysis is correct. So in my view, the question is, was it harmful error for him to deny our expert the opportunity to explain what those policies were that the healthcare providers? We had an expert, let's take the nurse. Have an expert that says, the nurse says, standard of practice is to follow hospital policies. That nurse is not qualified to say what those hospital policies are. That was Mr. Moore's job. That was the other half of that case. That's why the case against the nurses, that vicarious liability case, is tainted, because the jury never got to hear what our expert said the proper procedure was, which was to follow the instructions of the manufacturer, among other things. So we have a problem where if you look at the language, and I can cite you the pages, the court makes it clear that when he rules on directed verdict, he is ruling on ordinary negligence because he has already denied me the opportunity to put on any corporate negligence claim, administrative negligence claim. So he said to me, go ahead, we'll give you a voir dire. Now, that voir dire was not my whole case. That voir dire was me trying to jam a square peg into a round hole to get past this membrane that could not be permeated. My case is, and the case that we would have presented if we had been given the opportunity, is found in the record. It's on page 32 of the record. It's paragraph 31 of our complaint. And it sets forth, failed to educate and train and manage, failed to maintain adequate staff qualifications, failed to provide adequate qualified staff, failed to determine the key safety instructions, failed to ensure the staff was competent for what they were doing, failed to ensure that they used the shoulder braces in accordance with the manufacturer's instructions, failed to have in place adequate and sufficient protocols. Let's just take that one. That's the kind of thing that only an administrative expert, one who was the COO of Carolina Medical Center, can testify about. Ms. Simpson could not. So she was stuck with saying, yep, we have to follow the policy, but we weren't allowed to tell them what the policy was or should have been. They all admitted to what the procedure was in robotics. Lights on, do it like the instructions. You do not risk this. Why? Because you risk a brachial plexus injury. This is the very thing that all those instructions were designed to avoid. How did it happen? And I submit to the court that the proper trial is put it all in front of a jury and let them decide, was it a breach of the standard of practice? Was it a breach of the hospital standard of practice? Was it a breach of a hospital policy? All those kinds of things are what a jury should have decided with a full record. We were not given the opportunity to give a full record, so it's very unfair for us to have to face a directed verdict barrier. We were not given the 2 or 3 days to put on a mini trial, which is what it would have taken. Instead, we put in both, they deposed him for 2 days, they didn't like his testimony, both his reports, and the 30B6 depositions, the corporate depositions, which are in our 98 at the very back, of what those things were that would have been part of our administrative case had we been allowed to present it. So if Your Honor wanted, I could spend a month and probably gin together enough to beat directed verdict. But I wasn't given the opportunity to develop the record. The appellee should not ask this court to do what the trial court should do. This court should reverse, remand, send it to the trial court with instructions. You decide what comes in. That's not our job. The record's incomplete.
Mr. Trahey, do you believe if the trial court had the benefit of this court's decision and the Supreme Court's decision in Savino, that the trial court would have handled this differently?
Without question, even to the point of whether or not, one of the last things was it abuse of discretion to exclude the evidence of the robotic seat procedure. Normally that's, you can't beat an abuse of discretion, but when the decision is based on the fact that you're not allowed to present expert testimony about what the policy or procedure is, then you just can't win.
So that artificial dichotomy between administrative and clinical is what you're arguing prevented you from even being able to present your case against DB.
It tainted the trial in every way, at the management level, at the agency level, and at the policy level. We were not allowed to bring in any of that evidence, and that is harmful error. We were prejudiced by that. We presented half a case. I'll give you an analogy. Truck driver his job is to go pick up a load from the plant. He's got his CDL and he follows his company policies. The plant, because of the nature of the object, has very specific policies on how to secure the load to the flatbed. The guy doesn't follow those policies. He has an accident in a turn when the load falls off. You have two CDL experts testifying for both sides saying whether or not he violated the driver. But then the judge says to me, no, you can't put on the safety manager from the hospital, from the plant, about what the tie-down rules were. You're not allowed to do that because why? He's not a driver. That's why the case against the nurses needed to have both the expert testimony. We got them to admit that this was the procedure in robotics. And then when we got to trial, they said, well, this isn't robotics, it's laparoscopic. Only an expert can explain that the only procedure you have is the one that you use. That is why our trial court mistakenly kept out everything, including the fact how this device was supposed to be used by in the hospital, because why? It was not robotic surgery. Well, this device had never, ever been used for anything but robotic surgery, and a couple of things for men. It had never been used for a hysterectomy. None of the hospital policies were followed. We were not allowed to present that.
Would Mr. Moore have to meet the criteria of Rule 702B in order to testify as an expert?
He meets the criteria, number
Okay.
one. And number two, he, because of the timing of the incident, it's the pre-2011, so we weren't required to 9J him. But if you look, and my learned counsel opposite figured out that I had contacted him in February of 2014, we filed our complaint with our administrative allegations in March of 2014, after conferring with him. So we went from this from the very beginning as a systems failure case. That's what we tried to present. And the judge said, nope, all you can talk about is individual actors. And with our hand tied behind our back, our doctor was not allowed to testify about the nurse or the hospital. The nurse was not allowed to testify about anything but the nursing. So we were told, here, provide half a case, and it's not even your best half.
So without your administrative expert's testimony, can you survive a directed verdict on the administrative claims?
No.
Or you view that expert, and well, let me back up. So I take it your view is the Supreme Court's decision in Savino changed the law? Is that your view?
It clarified the law. It said that there's always been two kinds of negligence claims against the hospital that aren't related to the standard of practice for the individual. One is ordinary negligence, and one requires an expert to talk about what occurred. And that's what the Savino Court of Appeals said, that's what the Supreme Court said, and that's what we have always relied on, was the ability to bring concurrent claims, even disjoint or disparate claims, and let a jury decide what happened. It's very clear that this product was used wrongly. They can argue about whether it hurt somebody, they can argue about how it happened, but it's very clear that's what happened.
So if the standard for the admission of the expert testimony of a hospital administrator is something that we review for abuse of discretion, and if the trial court may have been making decisions based on incorrect understanding of the law that you say is clarified or, could be argued is changed in Savino, we would need to allow the court to exercise its discretion applying the appropriate law, but we wouldn't need a new trial for that, right? The court could we could remand and let the court determine if, based on the correct law, it would still exclude the expert, and if it would, then the directed verdict would be appropriate because there would be no evidence then that could allow you to satisfy all the elements of the claim. Do you agree with that?
You know, that's exactly right. You could remand this case, and defense could win because the trial judge did the right analysis. But that analysis was not done here. Instead, the trial court said there's no question that this witness, his knowledge base is extensive, his proficiency with hospital, his knowledge base, and his proficiency with regard to hospital administration, the regulatory guidelines attended therewith, and the safety training, and many other things that he has described and opined are extremely impressive. But most of all, it falls outside the purview of what he can say because it's clinical care.
Right, so how would we do that, though? We would remand for the court to have an evidentiary hearing that's essentially like a voir dire of the expert? Because, the trial is over.
The trial has to be retried because it was mistried. It ended in a mistrial. So we're going to go back anyway.
Well, that was my question, is instead of having a retrial, though, really all we need to assess is whether the trial court, applying the appropriate law, would have in its discretion still excluded this expert, and if so, these claims don't need to be retried. The existing verdict can be entered, and so I'm trying to understand if it can be done through a hearing and not sending it back for a trial.
It has to go back for a trial.
You're saying the other claim,
The court wants to have a pre-trial hearing would be wonderful.
yeah, the other
We'd love
claims
that.
are going back for trial.
Right, but this claim, well, my point is, this claim doesn't, by necessity, need a retrial. It's possible that if the court would conclude that applying Savino, your hospital administrator cannot testify as an expert under the rules of evidence, then the directive verdict was properly entered. That was the point I was making.
Yes, Your Honor, and my point would be that we need to have the trial court do that. We need to have the trial court do that analysis. It shouldn't be done on this record when we were not given the opportunity to do an offer of proof. He says, he even says, look, just make it robust and let the court, if I'm wrong, the court will reverse me. I'm sorry, he turned out to be wrong, and it tainted the whole trial. It was such a fundamental flaw that we cannot bring an administrative negligence with a proper expert that he called proper and qualified.
So back to...
That's an error of law is an abuse of discretion. I'm sorry.
No. I'm sorry to interrupt. Back to Judge Dietz's question, just to be clear, if this court remanded the case to the trial court to reconsider its decision on whether or not you can call this expert in light of Savino, there'd be an evidentiary hearing, and you are arguing, as you have been, that yes, and that evidentiary hearing would have to allow you to show to the trial court all the reasons that this expert is qualified under the rules of evidence, should be allowed to testify, and that the trial court can't be limited to the record which it so constrained.
This trial court said that this expert was qualified to give the opinions he gave, but he said that he was not permitted to give them because they dealt with clinical care. That's a big error. That can't be harmless. And I shouldn't have to show that we beat directed verdict when that's not what the issue was. The court said, look, I'm not going to allow any of this in, and if I'm wrong, the appellate courts will tell me, go ahead, stuff your record. Make it as robust as you want.
Yeah, I've seen those. I think we can acknowledge that the trial court anticipated there would be an appeal here because this is a complex area where I think this court's opinions were, somewhat contradictory, which is why I think Savino ultimately was decided by our Supreme Court. But so one follow-up question is, so where in the record can we see the trial court saying, I won't let you make an offer of proof, I won't let you put in this evidence for the appellate record so we can, just make that decision on appeal?
He never denied me. I never requested to do an offer of proof. And let me please say why. This case was very long. The judge was making it clear to me that I only needed to put in enough to show whether or not his analysis was correct. That's what he says. Let them, the appellate court, decide if my analysis is correct. Not whether I'm right on directed verdict, but whether I can exclude all of this evidence over here and then decide that, remember, he directed the verdict on ordinary negligence. He never ruled on hospital administrative negligence.
But under Savino, they're one and the same, right?
I'm sorry, say that again.
So under Savino, following Savino, would there really be two different directed verdict analyses or just one?
There would be an analysis of whether or not there was a claim made out sufficiently for corporate negligence.
Separate from
Separate.
medical
Savino, the Supreme Court said that it was an independent
theory?
means of finding medical negligence. They're not tied. They coincide all the time. Getting back to the nurse who has to follow the policy but can't testify about what the policy is. It's half a case.
So you're saying your expert was testifying about why the hospital was administratively negligent, but the judge thought it was all clinical, and so...
He had three purposes. One of those was to show they were administratively negligent, one was to show that their hospital agents were negligent, and one was to show what the hospital policies were or should have been in order to conform with the law. Three separate purposes, all of which were denied to us.
Okay. I want to warn you, got about 5.5 minutes left for both.
Thank you very much, Your Honor.
We're here from the appellate. Thank you.
May it please the court, counsel. My name is Tamara Coffey, and it is my privilege to represent Novant Health Medical Park Hospital in this case. Also here today is Linda Helms, who represented Dr. Masiello at the trial. However, Ms. Helms has ceded her time to me, and I will be making the argument in this matter. There are three distinct issues before the court. The first is whether the trial court was correct in excluding the testimony of Kevin Moore, a lawyer, former hospital administrator, whose opinions were grounded in a unique clinical care setting. The second issue before the court is whether the trial court was correct in granting a directed verdict for the hospital, in this case, on an ordinary negligence claim, also known as administrative negligence, where the only evidence of that claim was indeed Mr. Moore, who had no clinical experience and no clinical knowledge of the issues at hand. And the final issue before the court is whether the trial court was correct in excluding certain evidence of the routine use of shoulder supports, the equipment at use in this case.
So, counsel, I'm going to rephrase, I think, one of the arguments that your friend for the plaintiff is making. I want to get your reaction to this. So I can phrase it this way, that the trial court, it's the statements the court made in the transcript in light of the Supreme Court's decision in Savino suggests that perhaps the court was acting under a misapprehension of the law. And because the admission of expert testimony, the core question is will this be helpful to the jury? And that's a discretionary decision for the court. If we believe the court may have had a misapprehension of the law, and to be fair, the court could not have known what our Supreme Court would say in Savino, but we should send the case back to let the court make the same discretionary decision under the appropriate law. So what's your response to that argument?
Yes, sir. And respectfully, I disagree. And the reason is that Savino is not controlling in this case. Savino did not change the law. It clarified the law at the pleading stage for purposes of 9J. I argue that for defense lawyers and medical care providers, Savino is a very good thing, because now going forward, it is very clear that with an ordinary negligence or an administrative negligence claim, a plaintiff must have an expert witness under the pleading requirements of Rule 9J. I submit to Your Honor, Judge Dietz, that that's all Savino did. It did not change the underlying law and the principle of the common law that this court has held for many years, as well as the Supreme Court, which is how do you determine whether or not a plaintiff is making an ordinary negligence claim or a medical negligence claim. And I submit to you that the controlling law in this case are all of those cases pre-October 2011 and afterwards that analyze that old common law. And that the critical question for all of you to determine today with regard to Judge Hall's ruling is, did the alleged administrative negligence claim that the plaintiff sought to bring through Mr. Moore, did it arise from clinical care and clinical decision-making, or was it a purely administrative claim?
So your argument is the allegations are all clinical based and not administrative based?
Yes, sir.
And so therefore this Mr. Moore wasn't qualified to testify as to any of that?
Absolutely, Your Honor.
So so I just make sure he's claiming that he's making administrative claims, and you're saying there were no administrative claims under the prior law. All these allegations really do smack of clinical.
That's true, Your Honor. I'm saying that he attempted to make an administrative claim, and if you had analyzed that claim under 702H, going back to a question that Judge Inman asked, if you analyze Kevin Moore's testimony under 702H, which is the only prong that he would have qualified under, 702H very clearly says that an expert can testify to, quote, non-clinical issues. An expert like himself, a lawyer, not a doctor, can testify to non-clinical issues if he has, quote, substantial knowledge of those issues. In this case, our argument is Mr. Moore did not qualify because the issues he was talking about and purportedly talking about were clinical issues, not non-clinical issues.
So I found that argument pretty persuasive, but I guess my question is, where in the record can we find the trial court making that determination?
Yes, sir. If I may, first of all, let me say, Judge David Hall, and you may know him, this was a 7-week trial. At no time was the plaintiff not allowed to put on any evidence. We spent days, if not weeks, and certainly hours on this issue because Judge Hall came back to it every morning and every afternoon, before and after court. He spent hours on this. And if you know Judge Hall, he's one of those judges who doesn't take any lawyer's word for it, whether it was mine or Mr. Trahey's. He researched this himself. And to go directly to your question, what was Judge Hall thinking and where can we find that? If you look specifically on pages 2605 through 2607 of the trial transcript. And I believe this was the day he granted our motion to exclude Mr. Moore on September 27th. On those pages, Judge Dietz, he goes specifically through what the case is about and what it's not about. He goes through and he says, this is not a credentialing case. This is not an accreditation case. This is not a case about Joint Commission standards. And he says, this is not about a case, for example, where the hospital should have stopped Dr. Masiello because he was doing something clearly negligent. And he goes through that. And then he says this, and this is a quote. Mr. Moore's opinions are based on clinical care. They seem to be based upon deposition and testimony today, sort of inextricably intertwined with these actors, the defendant's provision of clinical care. In this instance, evidence of those things are precluded in my mind by the medical negligence claims, the malpractice claims, and the standard of care testimony already received with respect to each of the individual actors. And then he says this, now, what I am interested in is there still may be claims of ordinary negligence against, by, and through its employees, of course, a corporation, and I'm interested in what you have to say about that. And he's speaking directly to Mr. Trahey. And then he poses this question. Judge Hall says, is there a claim that Medical Park Hospital negligently failed to train their respective personnel with regard to these Allen shoulder supports? The answer of Mr. Trahey, found at page 2592, was, it is not our intention of arguing that Ms. Clubb, the OR nurse, was improperly trained. If that's not a waiver, it's very clear that Judge Hall was thinking there are two separate claims here. You can proceed on two different claims. And I'm giving you an opportunity. In fact, he was coaching the plaintiff to reformulate their ideas and their theories of administrative negligence, and that suggestion by Judge Hall was rebuffed.
Oh, if I could just, so Mr. Trahey just argued to us that the nurse expert testified that the standard of practice is to follow hospital policies, but that the testimony about what was in those hospital policies, such as, I think, following the manufacturer's instructions, didn't come in because that was with Mr. Moore. And when you're looking at hospital administration and policies such as that, I mean, it all ultimately relates to clinical care, right? I mean, the whole purpose of the administration of the hospital is to support the clinical care.
Sure. And to respond to that last statement, Judge Inman, this court, or neither the North Carolina Supreme Court, has ever expanded ordinary negligence in this setting, in this specific clinical setting, where you have an intraoperative emergent situation that occurred totally out of the ordinary that no hospital policy could cover.
Well, totally out of the ordinary, because as I understand it from the pleadings, these straps were never used in laparoscopic surgery.
That's correct, because that's not the clinical setting in which shoulder supports are used. And I'm not sure I answered your first question there, so let me go back to that. Judge Inman, the reason that the clinical setting is important in this case is that this was a situation where intraoperatively, and there's actually a case on point that I want to refer to later about this, but intraoperatively, a sudden emergent event occurred. The patient slid, okay? Never before had Dr. Masiella or any other member of the team used these Allen shoulder supports that are used in an entirely different clinical setting, and that's called robotic surgery.
Right.
They never used them before. No one had ever slid before. Everybody on this clinical team said this had never happened at our facility. It had never happened in our own personal experience. It was a unique clinical setting that required clinical decision-making as to how to address it. And the choice that was made was this device called Allen shoulder supports that were used in robotics because, pardon the use of my hands, in a laparoscopic procedure, you're head down, bottom up, legs in stirrups, at a 30-degree angle. But in a robotic procedure, you're head down, bottom up, at a 60-degree angle. So a much steeper angle, and that's why you use those shoulder supports from the very outset of robotic surgery. That was part of the analysis that Judge Hall went through on the last issue before the court, that these procedures are not similar, so you can't talk about how one Allen shoulder support is used in robotics versus another.
So based on that argument, if this panel were to remand this matter to Judge Hall to reconsider his decision to exclude Mr. Moore in light of Savino, your prediction is that you would win anyway and he would be excluded.
Nothing would be different. Nothing would be different because the testimony of Mr. Moore would not be different. And Judge Hall listened to that testimony for hours. And then he read his deposition that I took over the course of 2 days.
So what's the harm to your client if this court remanded it for that purpose?
the harm would be the additional hearing in front of Judge Hall that's not necessary in a case where I don't know how much more clear you can be arose from, and that's the standard. If we go back to Blanton, Waters, all of those cases, the standard is, did the opinion and did the administrative negligence claim arise from clinical care and decision-making or purely an administrative issue? And I want to go to your issue of policy for a second.
And Judge Hall would be exercising his discretion,
Yes.
right, in light of Savino. And extra benefit, you wouldn't have jurors cooling their heels in the jury room or on a recess.
That is true. That is true.
But please go ahead.
I want to address the issue of policy and to what extent Mr. Moore was going to address the issue of policy. I want to give you an example of exactly what Mr. Moore was going to say so that you can see how, under Judge Hall's words, it was inextricably intertwined. Mr. Moore was going to say, first of all, that the entire team, including Dr. Masiello, who he clearly would never qualify against because he's a lawyer, and Dr. Pinkar, he was going to testify that the entire clinical team should have stopped and should have done a dry run with the shoulder supports and taken an extra 20 to 30 minutes to do that before they continued the procedure. That was the kind of testimony that Mr. Moore was offering, and Judge Hall considered that. I don't know how much more clinical you can be. He was also going to say, going directly to your question, Judge Inman, that that would have been a violation of the hospital policy. How can he be qualified under 702H to render that opinion? It is not a non-clinical, pardon my double negative, opinion. Another good example of what Mr. Moore was offered to testify was on the issue of, one second.
So while you're doing that, this is, I think, the one issue I'm struggling with here, because I agree with you. I think what the trial court was doing was saying if it involves this clinical care, so if this is about treating patients, then the expert needs to be one who qualifies to testify about that. So a physician or some medical professional, not a hospital administrator. And I'm persuaded that is the correct law. Even, I don't think Savino changed that. But where I'm having a little bit of trouble is your friend for the plaintiff has listed off a whole bunch of theories of this administrative claim, and I don't see a place in the record where Judge Hall, the trial court is saying, now in my discretion, the expert cannot testify on this claim and this claim and this claim. And I think part of that is because the claims that we're hearing from your friend for the plaintiff, you look at the complaint, you can't sort of walk through and find, it's all a jumble to me. So I'm trying to figure out what we do about that. Can we be confident that the trial court considered every claim that the plaintiff asserted and concluded that these claims are all clinical care claims in exercise of discretion? This witness cannot be qualified as an expert to testify, and therefore there's not enough evidence, and therefore enter direct verdict. How do we know that sequence of events happened?
Am I going to be able to quote a page where it's tied up in a pretty bow that you have a list of 20 items that Mr. Moore was going to testify to, and Judge Hall considered each and every one of those? I can't tell you that, Judge Dietz, but what I can tell you is that over that 7-week period, he heard everything. What I also can tell you is that in addition to the 2 depositions, the voir dire, Mr. Moore wrote a report, and that report was attached and placed into the record as well. And I know that we spent at least a couple of our arguments, either in the morning or afternoon, where we went through that report item by item, and the one item that I just indicated to Judge Inman was one of his opinions was in that report. So I know that we went through his report and Judge Hall read it and considered it. I'm not going to be able to point to you, and it would be dishonest to suggest that there's a neat list of items where Judge Hall says, I reviewed each and every one of these. I can tell you it was exhaustive, and I can tell you that he considered it. And I want to give you another example because it goes back to Judge Inman's question about policy as well. One of Mr. Moore's other purported opinions was that Nurse Club and the CRNA, her name was Joanne Pearson, did not follow the manufacturer's instructions, and that was brought up by Judge Inman, in placing the shoulder supports. Again, I don't know how much more clinical that can be, because those instructions, which are also part of the record of this court, specifically state things clinically that a nurse or a CRNA or a physician should do at any given point in time.
Well,
Again,
I have a question. You have in your brief, and I'm just trying to get this fine membrane line between administrative and what's clinical. And you have in your brief, you just like, one example of administrative is you're not adequately investigating the credentials of the physician. So if a physician is credentialed but does something negligent, that clearly would be clinical. But if the physician is a veterinarian, that's clearly, and not a doctor, a medical doctor, that's clearly the hospital for not making sure. And one of the allegations is failed to provide adequate and qualified staff. So the allegation is not that the staff was qualified but did something negligently, but that the hospital, I guess, didn't ensure that they were qualified. So why would that not be the same thing as what you say here is not making sure that you had credentialed physicians? Why wouldn't that be administrative in nature? And I'm just talking about the allegations. I'm not saying it's true, but I guess you're claiming that Nurse Club or whoever was not qualified. The hospital didn't ensure she at least qualified. Not that she was qualified and did it negligently, but that she wasn't qualified to begin with.
Sure. And quite frankly, Nurse Club was the most qualified person in the room.
Well, I'm not the jury. So, explain to me why this allegation doesn't
Yes.
match what you claim
Yes.
the law to be.
Factually, and I didn't mean to be
Oh, no, that's fine.
funny about that at all. But in fact, just to clarify my statement, Nurse Club, at the time of the trial, had been elevated to the position of the market leader for robotics program for Novant Health, because she had been a robotics nurse for some time prior to this trial and prior to this case, which occurred in March of 2011. So she clearly was the most qualified in the room. That's why, Judge Dillon, I pointed out Judge Hall's comments in the record when he asked specifically Mr. Trahey, so do you want to pursue an ordinary negligence claim that Nurse Club was not qualified or not properly trained? That would be not qualified.
And they said no.
He said no, because he knew that she was, and that would not be the appropriate administrative negligence claim to make, number one. He also knew that he had already put on a medical negligence expert against Nurse Club, Lisa Simpson, who was the nursing expert for the plaintiff in the case, who had testified, in fact, that Ms. Club was qualified, competent, trained well, and she had no opinions whatsoever about her training. So he would have put on two different.
So Mr. Moore was not going to testify that somebody wasn't qualified.
No.
Just that whatever was done negligently.
No. He may have attempted, and I think he intended to. That's why Ms. Helms is here, and that's why my colleague, Ms. Horton.
He may have attempted to say what?
He may have attempted to say that Dr. Masiello or Dr. Pinkar had not been trained properly or were not qualified to use the robotics. But those individuals were not employees or agents of the hospital. They were private practicing physicians. And that's why Ms. Helms and others at the trial objected to Mr. Moore's testimony as well, because he clearly was not qualified to render opinion as per or as to the physicians in the case.
Did the jury receive evidence as to what the manufacturer's instructions were?
You know what? That's an excellent question, Judge Inman. My response to that is those instructions, I don't believe, were ever actually admitted into evidence. I could be wrong about that because this, again, was a 7-week trial, and there may be others who can say yes. But I know this. Those manufacturing instructions and what was contained within them were clearly discussed throughout the trial. Were those instructions admitted I honestly don't recall at this point in time, Judge Emmett, and I don't want to say anything.
It's okay, but
that's not
it's your argument that based on testimony, the jury had information to decide for itself
Absolutely.
whether those instructions were followed?
Absolutely. They had pictures, they had testimony of, and here's probably a good opportunity to say that there were 5 other expert witnesses for the plaintiff in this case, all of whom were clinical, and they had covered the gamut of all the issues in the case. And this is the important thing, and I want to talk about this for just a moment. What they had not discussed at any point in time was any administrative or ordinary negligence claim, and they had not causally related to the plaintiff's injury any ordinary negligence or administrative negligence claim. And that's the second reason that is contained within our brief, and I just want to hit on it very briefly, and that is that the directed verdict must stand, as well as the exclusion of Mr. Moore, because none of the opinions that he was offered could be medically causally linked to the plaintiff's injuries in this case. And as you know, that is required by the Wilson case, I believe it is, and let me make sure I'm citing the right case. Yes, it is the Wilson case from the Court of Appeals in 2017 that said that you had to have medical causation testimony to link ordinary negligence to the plaintiff's injury. In that case, and this is really telling, in that case, that Court of Appeals case in Wilson, they held that a PhD biomedical engineer could not provide medical causation testimony linking ordinary or administrative negligence to the plaintiff's injury. If a biomedical engineer can't provide it, a lawyer certainly can't provide medical causation testimony. And there was absolutely no causation testimony throughout the trial of linking up this ordinary negligence claim and administrative negligence claim. In fact, Your Honors, I would submit to you, you don't even have to address any of these issues. You don't have to get into the complexity of the standard to apply, the Savino case, how it fits in, because you need look no further than they did not present any evidence of medical causation to link the ordinary negligence claim in this case.
If we determine that there's an administrative negligence claim, would you concede then it would be appropriate to remand it so that the trial court judge could exercise his discretion based on the correct statement of the law? Is that what we're trying to decide? Is that really the key issue? Is this really an administrative claim, or is this really clinical? Is that the issue?
If you believe.
If we believe it's administrative, do we then have to believe that? I guess your second argument would be that even if we believe that, there's no evidence of medical causation.
That's right. Even if you believe it, there's no causation to link it up. I would also say, Judge Dillon, even if you believe that under Rule 702, Mr. Moore still doesn't qualify because these were not non-clinical issues, but I understand. But if you say they are, I would submit to you that under abuse of discretion standard, Judge Hall, it is hard to say that what he did was arbitrary in any fashion or without thought. And that's the standard with regard to the exclusion of Mr. Moore.
You were talking about abuse of discretion.
Yes.
But misapprehension of law is abuse of discretion, and
Right.
that is, it seems like out of the category of when we think of abuse of discretion, but that's also abuse of discretion, right?
Yes, ma'am, it is. And let me say this. Again, I'm going to go back to what I said originally in response to Judge Dietz's question. I don't believe Savino changed the law in this setting. Savino changed the law with regard to pleading requirements under 9J. Savino did not change the law as you apply the administrative ordinary negligence standard and how to view the difference between administrative and ordinary negligence and medical negligence.
It just said that if you had an administrative claim, you had to have a 9J expert.
That's exactly right. And that's why I don't believe there was any misapprehension of law given he didn't
It
know
didn't
was
move
coming.
the goalpost or the membrane or whatever.
That's right. It did not. Savino did not move the goalpost. What it did was clearly say there's two different claims. And now,
Which was always the law, it's just that the other one, you have to have a 9J.
right, and to Judge Dietz's point, the law in this area has been all over the map. And I want to go back to the one thing I told you I would do.
You have about 2 minutes, but go ahead.
Yes, sir. And that is the Locklear case, and what Judge Berger's dissent in that case said. And I want to read that to you because that Locklear case is almost identical from a factual standpoint. And it was a fall from an operating room table during surgery. And Judge Berger, now Justice Berger, said this in his dissenting opinion. The positioning and controlling of the plaintiff's body while on the operating table during active surgery, while plaintiff's body contained surgical tools, required clinical judgment and intellectual skill. The reason that's important, and I'll sit down, judges, is that no matter what case you look at, and as you know, there are an array of ordinary negligence versus medical negligence cases in North Carolina, both at the Court of Appeals and the Supreme Court. No matter what case you look at, it has never been extended to a clinical situation like this, where there was an emergency in the operating room, plaintiff on the table, and that called, any version of it called administrative negligence.
And so I agree with you that, and so I'm certainly persuaded that Justice Berger's reasoning was correct. And I guess the struggle I'm having is your friend for the plaintiff in the appellate briefing has all these claims that are that the plaintiff says are the asserted administrative negligence claims. And when I go back in the record, I don't find some clear indication that these were the claims that were being pursued. And my concern is if the trial court didn't understand that each of these claims and then exercised the court's discretion saying your expert is not going to be permitted to offer expert testimony here, so there's not sufficient evidence to direct a verdict, I'm not sure what to do. Do we just comb through the record and try to, I mean, it's an enormous record here, or do we just say to the trial court, let the plaintiff tell you what the claims are, make a determination about whether they're clinical or, and require a clinical expert, or whether you can have a hospital administrator, and then if you think your original ruling was correct, just re-enter the directed verdict. That's sort of a, but if I could figure it out, I would prefer to, I think because the trial court was inviting us to help aid the law here and not just return it to the trial court. So that's what I'm trying to figure out. And I've eaten into counsel's time. If
No,
you can allow her to
you
respond.
respond. That's fine.
May I just briefly respond? As I understand the struggle, and I think this would happen after any 7-week trial, because lots of things happen. What I can tell you is that I personally was there, and I personally had this struggle every day with Mr. Trahey and Judge Hall. And I can tell you that if there was a judge who ever considered everything, it was Judge Hall in that case, and he made the best decision that he could. And quite frankly, under the law, I think he's absolutely right. Thank you, sir.
Thank you so much. Rebuttal, about 5 minutes.
Yes, Your Honor, I'm having a little difficulty because that wasn't our argument at trial. And let me just say this. We heard a lot of characterizations of what happened without any citations to the record. If you look at the brief and the citations in the defense record, none of the things that they cite are true. For example, you just heard counsel say that robotic surgery is done at 60 degrees and laparoscopic surgery is done at 30. There's no such thing as any body being held at 60 degrees for any period of time homeostatically. If you will look on page 555 of the record, their own CRNA Pearson explains that the 30-degree angle from the pedestal that you're describing is the maximum Trendelenburg that the bed can accomplish. When we put on Dr. Mullen, he then went on, and we put on both brochures. They're in the record at pages 3 through 22. They are on pages 8, 13 and 21, you will see pictures of this device. It cannot exceed 30 degrees. Robotic surgery is done at 30 degrees. Laparoscopic is done at usually something in between. But so you have been told that the reason Judge Hall kept out the policy on robotics was because one was at 60 and one was at 30. And that is entirely disproven by the own record and by their own material received in discovery. So now they want you to believe their characterization of what happened at trial without any citation to the record when they've just cited you the same kind of egregious error that Judge Hall made. The only recourse for this court to do, please, is to remand with instructions to Judge Hall, as Your Honor might want to devise, giving him instruction on how to deal with this issue. Because the issue is, we are now permitted, if we weren't before, and I say we were before, to bring an administrative negligence claim with an appropriate expert.
Well, now, I want to make sure I understand. So I know I assume you're claiming that when the operation was proceeding, that they didn't properly, the people in the operating room were negligent in the way that they secured this woman. I guess that's one thing. How was the hospital negligent administratively in causing that to happen?
Because they did not have a policy to prohibit personnel from using a device contrary to the instructions. They had inadequate policies. That's exactly the kind of thing that the administrative thing that Mr. Moore was going to testify. Mr. Moore was going to testify about who was permitted to do what under the hospital's own policies that were established by law. We were never allowed to get into that. Judge Hall needs to understand from this court what Savino means, and he needs to look at it, and that is a great idea the more I think about it. Yes, let's have a pretrial hearing and decide what Mr. Moore can testify to with instruction from this court. But to say, I'm going to comb through the record and just uphold this when we were never, yes, we argued over this every day because I could not get over the fact that he was denying us half our claim. And so, yes, there were times when it got heated on the record. But we were always polite. Judge Hall is a wonderful judge. We've agreed to keep him on after this trial. We all love him. This has nothing to do with him. He is a great judge. He made an egregious mistake. He said so himself that if he's wrong, he'll correct it. So please, do the right thing. Send this back down with instructions on what is admissible for an expert who is an expert qualified, according to Judge Hall, to testify about hospital administration and management. And I'll stand by my brief for all its citations and its citations to the record.
Thank you for your arguments. That's our only case for today. We'll adjourn court, but we'll stay up here and then open up again for the ceremonial session.
All rise. This session of the North Carolina Court of Appeals is now adjourned.
Thank you.
Do you want to just be at ease for a few minutes?
Just be at ease.
And then-
Give you a chance to clean up.
Great. I need to get my materials too.
Okay, go ahead.